That is.
Good afternoon, Your Honor. Brian Tyson, I represent Mr. Davis for the 2:30 hearing.
Yep, I'm going to take attendance in just a minute. We have had a virtual collision, and I'll clear all that up in a moment. So
certainly, thank you, Your Honor.
Sure. Okay. So for those of you on virtually, I'm Judge McBurney, and we have two things that we're going to tackle right now in the following order. We're going to handle the sentencing in State versus Williams, with the jury just having come back with its verdict. And then we will pivot to the hearing in the matter of Frails versus Raffensperger. So if you are on Zoom or in the courtroom for Frails versus Raffensperger, sit tight. You're welcome to mute, turn your video off. You're welcome to listen in, but we need to do this sentencing first, and then we will talk about the Frails matter. All right, I think we're good. Ms. Rivers, are you ready?
Yes, I'm ready.
All right. Let me do one more thing. Okay. Let's get back on the record in the Williams matter. A few moments ago, the jury came back with a verdict of guilty on all counts, and we are going to move into sentencing. Mr. Abate, if you would give me first your sense of what the sentencing options are, based on merger, vacatur, et cetera. And then I'm happy to hear your argument. And if there are any members of Mr. Hardesty's family or friends of Mr. Hardesty's who want to be heard, I will certainly hear from them as well.
Yes, Judge. Obviously, count one, the defendant would be sentenced on. Counts 2 and 3, felony murder, would vacate by operation of law. Count 4, aggravated assault, would merge with count 1. And then I believe Your Honor would sentence on counts 5 and count 6.
The criminal damage to property doesn't merge into the felony murder because it's been vacated, because there is the murder conviction and it stands alone. But the aggravated assault merges because it is an element, if you will, of the murder.
That's correct, Judge.
Okay.
And if it's okay with the court, there are 2 impact statements from Mr. Hardesty's mom and dad, Ms. Sherry Malone and Mr. Rodney Brown. And then upon the completion of their statements, the state will make a recommendation to the court as to what the state believes is the appropriate sentence. Okay.
And those are things you're reading, or those are people who are here?
They're here and present.
Great. So the way we're going to do that so the court reporter can hear you is I'm going to have you come up and you can sit in the chair that Mr. Abate is setting for you, so that we can get your statement. So in whatever order you'd like to be up here, please.
Probably so. Just in my mind, it don't matter.
That would be Michelle. Huh. Okay. Good afternoon, sir. If you could start by sharing your name for the record.
Rodney Brown.
Can you pop the camera up? All right, Rodney Brown.
Yes, sir.
All right, Mr. Brown. What would you like to share with me?
He took away something from me that I can't replace. That was my only son. And it's just, it's gonna be hard on this family without him. These last years been rough. And it's just nonsense. It don't make sense. And then just try to swear his name the wrong way, talking about he robbed him. He ain't robbed that man. He ain't took nothing from nobody. He didn't have to take. And it's just lies, and he ain't gonna go away like that. We had a good son. And just can't be done, man.
How old was Mr. Hardesty when he was killed?
35.
And that's your only child or your only son?
My only son.
Only son. Did he have kids?
Yes.
How many?
One.
One? How old?
He's 2.
All right. Anything else, Mr. Brown?
No, he didn't.
Okay. I appreciate you being here throughout the trial. Thank you.
Yes, okay.
Thank you. State and spell your name for the record, okay?
Okay. Hello.
Hello.
My name is Sherry Malone, and I am the mother of the deceased Tyrone Hardesty. He was my oldest son. I just feel like he was just taken away from me. We were real close. We just was close. I just don't understand this right here. I don't. Why? But man, I have to explain to my granddaughter. She's 4 years old. She always asks me, when my dad coming back? I mean, I don't, it's just hard on my family. My daughter, she couldn't even come. So it just hurt her. She been hurt and not working or nothing since this happened. And I just want the court to know that he took a fine young man. He was. Not just saying that because he was my son. He hadn't been in no trouble since 2006. He was trying to do the right thing. He was putting his music out there, posters everywhere. Why would he do something to jeopardize that? He had made a movie for Tubi. All his music on Spotify, Apple, and we've been getting a lot of hits or whatever, but he not here to see that. And he always told me, Mama, I'm gonna make you rich. I'm gonna do that for you, Mama. And it just hurt me so bad. He was my first love. No man, nothing but my first love, my child. It's gone way too soon. Just way too soon. No, it's senseless. And I want justice for him today. Thank you.
Ms. Malone, thank you for being here. One quick question. Your granddaughter, meaning Mr. Hardesty's daughter, who does she stay with her mom?
Her mom.
Okay. All right. But you get to see her?
All the time.
All the time. Good. Okay. Thank you.
Thank you.
Mr. Abadi?
We don't have any additional victim impact statements. Ms. Robin Cook is present. She'd like to make a quick statement now.
Okay. Welcome back, Ms. Cook.
Yes,
Tell me what you'd like to share.
I just want to say that this young man took somebody very special to me. And that night, since that night, has not been very easy for me. And being there and having to meet there that night and dealing with that was very difficult for me. You took somebody very special to me. And I could never get that back. I'm dealing with that every single day, every day. And I don't understand why. And will never know why this actually happened. But I just want to say, I just want justice for Tyrone. All right, that's it.
Okay. Well, Ms. Cook, I appreciate your testimony as well as this statement now. You've taken important steps to ensure that what you are hoping for happens. Okay?
Yes.
Thank you.
With that, Judge, the state's recommendation as to count one murder. The state recommends to the court to sentence Mr. Williams to a sentence of life without the possibility of parole. As to count 5, criminal damage to property in the first degree, 10 years to serve concurrent with count 1, and then count 6, possession of a firearm in the commission of a felony, 5 years to serve consecutive to counts 1 and 5. And recommending to the court a sentence of life without the possibility of parole is not something that I do very often. I take and understand the seriousness of making such a request, especially a request as it relates to someone who is now 22 years old, as he sits before the court, found guilty of murder and the other related charges. But in this instance, I feel compelled and I feel that it's necessary to make such a request to the court based on the facts and the evidence and how they unfolded in the courtroom over the last week during this trial. It was uncontroverted that Mr. Hardesty was shot in the back 6 times, and it was clear, at least to the state, based on the evidence, he was shot not knowing that anybody was watching him, that a gun was on his back. As he finished wrapping presents, or was about to finish wrapping presents, once he got the flyers out of his vehicle, he was gunned down, and we may not know why, but in the state's opinion, I don't need to know why. I know that the violent acts that this defendant took are heinous, they are unconscionable, and to be frank with the court, in looking at some of the documents in the jail screen here, as he has been at the Fulton County Jail, he's not, the lack of remorse for this instance has continued, as he most recently, there's reports that he stabbed an inmate while the inmate was sleeping. So in taking all of the totality of the circumstances for this case and the defendant's continued behavior, the state's opinion is the only appropriate sentence as it relates to count 1 murder is life without the possibility of parole. And then the remaining counts, count 5, 10 years to serve concurrent, and then count 6 must run consecutive, 5 years to serve consecutive to counts 1 and 5.
All right. Thank you. Ms. Feely?
Thank you, Your Honor. As the court has heard, Mr. Williams is 22 years old. He was 20 at the time that this happened. At the time that this happened, he had no felony record. He was born into a situation where he lacked some supports that he needed and an environment that lacked opportunities. He's got 3 brothers and a single mom living where he lived at the Columbia Commons. My sense from working with him is there's some undiagnosed, maybe mental health issues, that he was self-medicating with various substances that he had access to. And we are not minimizing the seriousness of this crime or the hurt that was caused by his actions, but we are respectfully requesting the court consider his record and his age. And we're asking for, on count 1, life with, and on count 5, a concurrent 10, and then on count 6, the 5. and that he be given credit for time served since January 11th of 2023.
All right. Mr. Williams, you have a right to say anything if you want to. You don't have to say anything at all, but much like the victim's family has a right to be heard in a setting like this, you've got a right to be heard. And I got to hear from you some because you testified, but if there's anything more you want to say, now would be the time to say it. But just like your decision to testify, you don't have to say anything more if there's nothing more you think needs to be said.
It was an accident that harmed Tyrone. However, this was definitely for no reason. That man robbed me. That man took from me, whether people believe it or not. And how I feel, before I take a life sentence, I would rather die, honestly. And unfortunately, I'm not gonna be able to see my little girl. She's 9 months. I didn't even get to see her when I was out because my baby mother was pregnant with her at the time. However, it's still in my beliefs that this is not justice. I defended myself and I was robbed and beat by that man. I did not want to harm this man. His actions led to his consequence.
All right, Mr. Williams, appreciate you sharing that. I struggle with some of the same things that Mr. Brown and Ms. Malone shared, which is Mr. Brown said it doesn't make sense. Ms. Malone says it's senseless. It just doesn't add up. Whether you were afraid of Mr. Hardesty or not, whether we credit your version of events to the point where you're way up on the third floor balcony, you had so many opportunities to get out of that situation. But what you chose to do was to fire at the man, whether he had a gun or not. The jury listened carefully to what you had to say and found your version of events to be not as compelling as all the other evidence that they received. And there are many tough aspects of this. There are a lot of broken relationships and empty seats at tables. Primarily, I worry about Mr. Hardesty's family, his daughter, and his family. But there's another empty seat, and that would be where dad ought to be sitting for your daughter. You're not going to be able to sit there and help take care of her because of the choices you made on December 22nd, 2022. And the toughest part for me is that the way Mr. Brown and Ms. Malone and Ms. Cook talk about it, where you took something, no one can get you to give it back. You took something, but what you really did was destroy something. Mr. Hardesty doesn't get to come back. People have the memories, but the steps you took are as permanent as they can be. You didn't take his car and people are sad and maybe you get the car back or insurance pays for it. But you took a life, and those are things you can't give back. And for that, the consequences are very, very serious. No one's going to gain from the fact that you're going to spend many years in prison. You will spend more years in prison than you've been alive so far. That's a strange outlook that you're going to have. And none of that brings Mr. Hardesty back, but it is the appropriate consequence for your decision to fire not once or twice, but at least 6 times at a man who the physics don't lie. His back was to you. And it's hard to square that with a claim of self-defense, but I don't need to resolve that. The jury did. And I'm left with a verdict for a 22-year-old who has no adult felony criminal history. And as I balance all those things and the notion that a sentence is designed to punish and there's punishment coming your way, but it's also to be focused on rehabilitation, and it needs to be proportionate. You don't have the background that convinces me that but for locking you up, more people are going to die. I see defendants like that, and that's not you. I'm going to sentence you, Mr. Williams, on count 1 to a term of life in prison. Counts 2 and 3 are vacated by operation of law. 4 merges into 1. Your sentence on count 5 is 10 years to serve. That will run consecutive to count 1. Count 6 must be 5 years, and it must run consecutive to the highest count, which now is count 5. And I am making that a term of incarceration as well. So your sentence is life plus 15 years. You will get credit for the time you served. I need to talk to you about your appellate rights. Ms. Feely will talk to you about this more, but the important thing is that you've got 30 days to have Ms. Feely to file on your behalf either a motion for new trial, which is you saying, Judge, there were mistakes made, you made them, my lawyer made them, and I ought to have a new trial, or, and you do one or the other, a direct appeal to the Supreme Court because you've been convicted of murder. Your case goes straight to the Georgia Supreme Court, appealing whatever mistakes were made here. You can do both, however, and your lawyer may advise you, we'll start with the motion for new trial, because if I deny that motion, you still get to appeal to the Supreme Court. But you need to decide that. And my request to Ms. Feely before she withdraws from the case, because you'll get a different lawyer appointed to represent you, before she withdraws from the case, that she consult with you. And if it is your decision to file the motion for new trial, she takes care of that. If instead you want to just go straight to the Supreme Court, she files that notice of appeal. When you've exhausted your what we call direct appeals, which ultimately would get you to that Supreme Court, or if you choose not to pursue them at all, in other words, you let those 30 days pass, you also have 4 years in which to file what's called a habeas challenge. That's actually a civil lawsuit. You don't have the right to an attorney to help you with that. You'll have an attorney helping you with all those direct appeals I just described. You don't need to worry about paying for that. But once you get to habeas, that's you. And if you can hire a lawyer, it's your lawyer helping you. Otherwise, it's you doing that. But that deadline doesn't start running until you decide you're done with your direct appeals. Then you've got 4 years after that to challenge the constitutionality of your conviction and your sentence. Do you feel like you understand the deadlines that you have, Mr. Williams?
Yes.
Okay. Ms. Feely, you'll consult with Mr. Williams about those?
We've talked a little bit, but yes, I'll.
Okay. And whatever his directions are, you'll take those steps, and then we'll work on, if it's to pursue some form of a direct appeal, we'll make sure different counsel gets appointed. All right. Thank you. Mr. Bate, anything else in Mr. Williams's case?
No, Your Honor, nothing further from the state.
All right. Ms. Feely? Do you have a question? A statement. So we're past the statement times. You can talk with Ms. Feely back there, but I got to hear your statement, and we're going to move past that. I would ask Deputy Gordon that you contact your colleagues at Union City based on Mr. Williams's observation about how he's feeling right now, so that people are keeping eyes on him. Okay? All right. Thank you. Mr. Brown and Ms. Malone and Ms. Cook, this doesn't bring Mr. Hardesty back, but it's a new chapter now. It's not a case where nothing was done about this debt. It remains senseless, It doesn't make sense. And it's now not the case because that sentence was imposed that Tyrone's going to pop up in your life tomorrow. The memories are there, and you should know that everyone took this seriously. Mr. Abate worked real hard with Mr. Rao to bring this chapter to a close. And my hope for the three of you and everyone else who's been touched by this loss is that while you never forget, you know that other people didn't forget either. And hopefully that brings a little bit of solace as you try to move forward. But I appreciate you all being here, okay? All right, thank you. You may, and Ms. Feely, thank you, and Ms. Rios, thank you for your time both. You guys have a good weekend. Ms. Rivers, thank you.
Okay. Y'all have a nice weekend.
You too.
I mean, well, it's natural. Oh,
So, yep, there we go. You're there, and you are on Spotlight, and get one more. Okay. Hello, council. I know some of you were trying to be here in 8D, but the spirits that control the perimeter and other roads like that made that not possible. So I hope no one panicked too much, and we're starting a little late because this murder trial just ended, and it was important to sentence Mr. Williams. He stabbed someone a couple days ago, and the goal is to get him to the Department of Corrections ASAP. And the family of the deceased was here, and they needed whatever closure this is going to bring. So we are pivoting now to talk about the Frails versus Raffensperger, and I want to add to the screen any of the other lawyers who need to be a part of it. And we're going to basically figure out, are we talking about anything at all, or this isn't the right day, or this isn't the right judge. And I'm happy to talk about all those things. I just want to make sure I've got the right folks. These were the three lawyers that Ms. Strong and Ms. Niles indicated I ought to make sure I can see and hear, whether it's in person or virtually. Why don't I start with Mr. Frails' counsel? Good afternoon.
Good afternoon, Judge McBurney. I'm Julie Oinonen with the law firm of Williams Oinonen. I represent Mr. Randolph Frails, who is the elector challenging, and he is also the president of the Georgia Alliance of African American Attorneys, and he submitted this petition for judicial review.
All right. And Mr. Willard, you are representing the Secretary of State?
That's correct, Your Honor.
All right. Good afternoon to you. And Mr. Tyson, you're representing Mr. Davis?
That's correct, Your Honor. Good afternoon.
Good afternoon. All right. And Mr. Tyson, you filed a motion to intervene. It's not inappropriate for you to be here anyway, but I think there's the procedure is underway to get you formally in the mix.
Thank you, Your Honor.
Okay. All right. Well, let's talk about what we're going to talk about. I shared an email with the lawyers, I can't remember if it was Tuesday or Wednesday, with my thoughts about how we ought to move forward. It seemed pretty clear to me that I could handle the motion for to stay the certification. But then I left it open to the lawyers about how they wanted judicial staffing to work for a decision on the merits. And I really didn't expect there to be any opposition to it being a different way, but there are always surprises in litigation. And so, Ms. Oinanen, I'm going to start with you, and you let me know what you were thinking we'd cover today and what you're objecting to or not objecting to. I don't want to subject anyone to my rulings if they think that isn't the right way for us to move forward.
Yes, thank you, Judge McBurney, and thank you for all your efforts to accommodate the parties here today. So we very much want to reach a practical resolution for all parties concerned. It would, I think, be in the best interest of everyone if we could simply stipulate to a stay and then try to get a hearing for the petition on the merits as quickly as possible. To me, that makes the most sense. To me, it doesn't hurt anybody, and it's certainly in the public interest to do that. My understanding from my colleague, Attorney General Willard, is that the Secretary of State does not have a deadline until June 7th to certify. The other thing that I felt concerned about was, you know, Your Honor, you've got a reputation for being a very fair judge, and we appreciate your forthrightness in terms of saying, look, I've got a relationship with both parties and that I admire and respect them both. I'm sorry, candidates, not parties, candidates. And that your intention was to recuse yourself on the merits. And so when we read that and thought about it, we realized, well, doesn't it just make sense that you would you would recuse yourself on the entire matter? But again, we want to be practical and efficient. Delaying this even further in a scramble to find a new judge may not be in the interest of anyone. So, you know, I'm here to try to be open to figure out a good resolution that would address and meet everyone's concerns. In the email I expressed, I did say, Your Honor, I'm moving that you recuse yourself regarding this issue, but I'm certainly, you know, want to discuss this practically. And, you know, certainly if Your Honor feels that you can fairly rule on this issue, then certainly you could decline or deny my motion to recuse. But I'm open to hear from everyone, you know, the parties here today, and just hopes that we could come to an understanding and figure out when we can actually be heard on the merits. But it is very, very important that we get a stay, because if Secretary of State Raffensperger decides on Monday or Tuesday to certify the election, our very significant concern is that then this case, his appeal, Mr. Frails' appeal, could become moot. And that's why this stay is so important for us.
Okay. Well, I'll hear from Mr. Willard in a moment, but I do need to correct something you said. And my email has whatever words are in it. It's a standard approach I take when I believe that an outside observer looking in could say, should we discuss this notion of, is this the right case for this judge? I didn't say I was going to recuse. I gave the sides an opportunity to discuss and decide amongst themselves without having to identify themselves, is this the right case for this judge? Because of what I disclosed, which is I have worked professionally with Ms. Ponder through work I do for Access to Justice. I have worked professionally with Mr. Davis through work I have done with the JQC. And I suspect all of you knew that, but I don't ever want to assume. And so I disclosed that like I should. And what my email said was, you all should talk about it. And if you don't file by a certain date, a notice saying, Judge, we're fine having you stay on the case for things beyond the question about the stay of the certification, then I will roll off. I didn't mean to convey, and I don't think I did, but subject to interpretation, that I was recusing. I don't think there is a basis for it, but I didn't want to make one side come out saying, well, we think you're an unfair judge. Because to recuse a judge, you have to point to some bias or prejudice that a judge has. It's not something people do lightly, and I trust you wouldn't. But I don't believe that my professional connections with either candidate, and to be clear, they're not even parties to the case, but it's what this is about, merited disclosure. And so I disclosed that. So I didn't say I was going to recuse. I left it to you all to decide. And then you, Ms. Oinonen, said, hey, should I file something, or are you just going to do what you said? And then I got swept up in the murder trial, and so here we are again. I am happy if there is a concern on behalf of your client that this would be an issue, to step aside. That's why I flagged it in the way that I did. I'm also happy to do my job as the judge to whom this case has been assigned, and I don't feel like I'm operating under any impairment at all. But I also don't want to dive into that right now, because there's not a motion to recuse, and you know how those work, and it needs to be an affidavit and this and that. But I'm going to operate consistent with the email I sent, which is if there's not something in the docket already, and I don't think there is, then at least one party has decided that this isn't the right way to proceed. That leaves us with the stay. And I thought I was clear in the email that I intended to handle that. And then maybe I just wouldn't be involved when the matter reached the merits. But if there are concerns about my involvement with litigation over a stay in the certification of the results, then that's the little piece we should talk about. Otherwise, I do think we should get into the substance of what this hearing was set down for, which is this emergency motion filed by the petitioner to stay the certification of the election results. But let me hear from Mr. Willard.
Thank you, Your Honor. And just to clarify, you're wanting me to address the issue of whether we will agree to a stay, or I'm not certain what is pending before me at this juncture.
Maybe nothing at all, but I heard from one side, and as part of being fair and balanced, I want to hear from the other side. Ms. Oinonen offered something of an opening statement, and hey, it makes a ton of sense to stipulate to a stay that doesn't harm any party. I'm paraphrasing, but that was the gist of what she was saying. And so you may say, I didn't plan on giving an opening statement, but I didn't want to say, here's what we're doing next, without you having had an opportunity to give the perspective of the Attorney General on behalf of the Secretary of State.
Thank you, Your Honor. I will start out by saying we have, I think, waived to some extent the provisions of 910-2 to be here before the court today. We stand ready and willing to address any legal argument revolving around the request for a stay by the petitioner complainant. We cannot stipulate or agree to a stay. Ms. Oinonen and I talked earlier this week, and I have been diligent in looking at it, analyzing the appropriate statutory law and case law since we spoke. I've discussed it with my client. I think our bottom line is, and we will have argument on this point, Your Honor, but just to go ahead and put it out there, I believe that whatever authority this court may have possessed under OCGA 2125 expired on the date that the votes were cast. And now that we are beyond that, for this procedure, which is the OCGA 2125, what the Supreme Court has titled a pre-election qualifications challenge, that the time has run and that this case is now moot. That does not mean that Ms. Oinonen, her client, or others may not have alternative remedies available to them, but it is not through the OCGA 2125 process. And it is our position that this court lacks authority to do anything at this juncture now that the date upon which votes were cast has passed. That's the entirety of our opening.
Okay, so I shouldn't handle the case and I don't have authority to handle the case. We're off to a bad start. Mr. Tyson, I'm not going to get input from you quite yet. When we're done, if there are things you want to chip in, I'll want to hear those. But I think what's most appropriate is that I just oscillate between Ms. Oinonen and Mr. Willard. So Ms. Oinonen, you heard it, I heard it. There's not going to be a stipulation. Do you want to go forward with a more robust discussion about a stay, the authority to impose a stay, et cetera? Or would you prefer, consistent with the email that you sent in a very timely way, again, I got swallowed by the murder trial, would you prefer that what I do before the day is out is get this case back on the wheel so that it goes to another judge?
We believe, based on the email, and I'm looking at it carefully right now because I definitely don't want to put words in your mouth, Judge McBurney, that were not there. You had stated that unless there is a joint filing by noon on Friday indicating that the parties have no concerns about me remaining on the case, and let the record reflect we're past noon on Friday and there's been no joint filing, I will recuse following my ruling on the motion to stay certification. So because of that statement where you had expressed to us that you will recuse yourself following the ruling on the motion to stay, then we would respectfully request that it would just make sense to go back on the wheel and have the clerk assign a new judge that would handle the matter in entirety. That would be Mr. Frails' preference, Your Honor, with all respect to this court and appreciation for the accommodation you've been so far, very accommodating for all of us.
Mr. Willard, do you have any objection to us moving forward that way? I understand your position is it doesn't matter who the judge is. Judge McWonderful couldn't do anything from your perspective because the authority has expired, because a pre-election, it's almost by its name, a pre-election qualification challenge doesn't have any legs now that we are in the post-election phase.
Your Honor, I would simply point out at this juncture, and just so that there is no argument of unfair surprise or anything like that, as I alluded to earlier, the Attorney General has waived at least some of the 5-day notice period under 910-2 in order to accommodate this hearing today on the stay. If this goes back on a wheel, or for that matter, if something happens between the conclusion of this hearing and you're still assigned to the case and you set a hearing for next week, the provisions of 910-2 still come into full force and effect for any subsequent hearing. I will work closely with the court and with opposing counsel, but it will be another instance where our office will need to decide in consultation with our client whether we waive some or all of 910-2's protections in order to accommodate a hearing that takes place after today. I will note that for the record.
Right. Well, I appreciate you doing that, and that may have been more for Ms. Oinonen than for me. What I will do, since you don't seem to take a position as to whether we hand this to yet another judge, ultimately maybe to a judge in another circuit, and maybe someday there'll be a hearing on this rather than today when a judge was ready to do it. We'll see where the case lands, and I will wish you all the very best. Mr. Tyson, anything you want to add to this?
No, Your Honor. Thank you for your time and working through this with us.
Okay. Happy to. Anything else on behalf of Mr. Frails?
Your Honor, is there anything that we need to file on behalf of Mr. Frails that you expect from us today, or will you simply be assigning this to the clerk of courts?
So I will file something when I am able to file something that will indicate that I am recusing. And then the clerk of court will do what she always does, which will be to get it to yet another judge.
Thank you, Your Honor.
All right, Mr. Willard, anything else?
No, Your Honor, thank you for accommodating us today.